My name is Austin Lux. I'm a criminal defense attorney in Colorado Springs, Colorado, and these are the top 5 defenses to a DUI charge that I've seen in my practice. So number 1, which is number 1 for a reason, is that I wasn't intoxicated or impaired. And I use those two terms for a reason. Colorado has 2 different charges for alcohol-related driving offenses. There's the charge of DUI, which is driving under the influence. It means that you were substantially incapable of safely operating a motor vehicle. And then there's a lesser charge of driving while ability impaired. It's known as a DWAI charge. And that just means that you were impaired to the slightest degree by the use of either alcohol or drugs. And so when you're looking at a defense to either of these charges, the first defense is always going to be, well, are they able to prove that you were intoxicated or impaired? And there are a lot of things that look like impairment during a DUI investigation that can end up having an innocent explanation. So one of the things that's commonly used by officers as evidence of intoxication during their investigation is somebody's performance on what are known as the roadside maneuvers or the standard field sobriety tests. So those tests are different movements that somebody does in front of an officer, and I'm sure you've seen it before. They're the walk and turn movement down the side of the highway, standing on one leg, those types of things. And these are physical maneuvers that somebody has to do. And an officer will take somebody's poor performance on those maneuvers as evidence of intoxication or impairment. Well, we have a lot of clients that have a pre-existing injury, which makes it difficult for them to satisfactorily perform those roadside maneuvers. And not because they're impaired, but because of a physical disability that they have. Here in Colorado Springs, we have a large number of military service members and veterans, and those individuals almost always have some kind of service-related injury that's going to make those fine motor movements that are required to pass those roadside maneuvers very difficult for them to perform even when they're stone sober. Another item that's going to go towards that category of intoxication or impairment is going to be the results of a chemical test if one was performed. And there are certain presumptions that apply if your level comes above a certain blood alcohol content as a result of those chemical tests. But that chemical test also needs to be examined to see if it was satisfactorily performed so that it yields reliable data. There's always going to be a range of error in these chemical tests, and that needs to be brought to the attention of the prosecutor as well. Now, the second most common defense to a DUI charge is that you weren't driving, right? So DUI means driving under the influence. So driving's got to be a part of it. And in Colorado, there's a much more expansive definition of driving than you might think. It doesn't necessarily mean that you're operating a vehicle while in motion, like down the highway or a side street or something like that. It can be defined as broadly enough to mean that somebody had the ability to put that vehicle into motion with relative ease. That's the definition we use here, is that you were in actual or physical control of the motor vehicle. So police officers will use that definition to charge people who never had any intent of driving with the crime of DUI. We see that a lot in domestic situations where somebody has a fight with their significant other and they're sleeping in the car, or situations where somebody left a bar but didn't want to drive home and were sobering up in the vehicle. So in Colorado, the determination on if somebody was in actual or physical control of the vehicle is a jury determination, and juries make that based on the totality of the circumstances. So things they're going to look at are the placement of the keys in the vehicle. Were they in the ignition or were they in your pocket? The statements that somebody had made prior to that. And I'm heading home, I'm driving away, or I'm going to go sleep this off in my car. All of those things come into play. So that is a significant defense if the case didn't involve a traffic stop, but rather contact with somebody who was in a vehicle that was already stopped. Defense number 3 is that the stop was illegal. So police officers need reasonable suspicion of criminal activity to stop a person who's driving. They can't stop you from driving based on a hunch or the fact that it's late at night, or you had left a bar, or you're in a bad area of town. Those don't qualify as a reasonable, articulable suspicion of criminal activity. And so if the reason that the police stopped your vehicle was not appropriate and was not based on either an actual law violation or a reasonable suspicion that there was an ongoing law violation, then police officers are not allowed to use the evidence that they collect following that stop against you in a criminal case. So oftentimes, if that evidence is suppressed, then that'll gut the DA's case, and they won't be able to proceed forward with the DUI prosecution following a successful motion based on the illegality of the stop. Defense number 4 is that you weren't offered a chemical test or the test of your choice. So Colorado has what's known as an express consent law. And what that means is that if during the police officer's investigation, if they develop probable cause to believe that you were driving while under the influence or impaired, then that officer has to offer you a test to determine the amount of alcohol or drugs in your system. Now that test can be either a breath or a blood test, and absent extraordinary circumstances, that police officer has to give you the choice of selecting one of those two tests. The only time that police officers can limit your choice of a test is if there are extraordinary circumstances which prevent one of the tests from being conducted. So a good example of that is going to be if the police officer suspects impairment by drugs rather than alcohol, or a combination of alcohol and drugs, then they can limit the choice to a blood test, because only blood tests will reveal the amount of drugs in somebody's system, while breath tests will only show alcohol. Now, absent extraordinary circumstances, if the police officer limits your choice of a test inappropriately, then that's a violation of either your constitutional right to due process, meaning the ability to preserve the evidence that you can use in your defense. Because remember, a test can be both inculpatory, meaning evidence of guilt, but it can also be exculpatory. It can also show that you were not intoxicated. And if the police improperly deny your choice of a test, and they've denied your due process right to preserve that kind of evidence that you need for your defense. So if police officers don't allow you that choice of a test, and you don't take a test, then typically that's going to be a violation of your due process rights. And if they limit your test and you do end up taking whatever test they're allowing you to take, well, then that can be a violation of Colorado's statutory right, which says that they have to offer you the choice of one of these two tests, and that can lead to suppression of whatever test results come back. And that's actually the reason why a number of DUI cases here where I practice in El Paso County have been dismissed over the last year and a half period, was because police officers just stopped offering suspected DUI drivers the choice of a breath test. They limited it to a blood test, and they did that without sufficient justification. So that's a significant defense if the officers didn't comply with the express consent statute. All right, defense number 5 is that the search or the interview was illegal. So oftentimes following a DUI arrest, police officers will search your car to see if there's any evidence in there of the DUI. And oftentimes they'll try and do an interview of you to see if they can get some additional information from you that's otherwise incriminating. So an admission to drinking and driving or something along those lines that they can use later on in court. Well, there are certain standards that have to be met before they do this. There used to be a number of exceptions that allowed police officers to do this without judicial intervention, but a number of those have been rolled back. And so if police officers arrest somebody for a DUI and they don't take the time to impound the car and then go and ask a judge for permission to search, which is done through a search warrant, then that search may end up being illegal. And if the search is illegal, then the evidence found in the car has to be suppressed and can't be used against you. Similar requirements go for an interview. So once you're in custody, so think putting handcuffs and placed in the back of the police officer's vehicle, well, then that officer needs to advise you of your Miranda rights before they can go on and ask you questions which are designed to elicit an incriminating response. So the standard is that if you're subjected to custodial interrogation before your Miranda rights have been read to you and before you waive those rights, then those statements that come afterwards, those can be suppressed. And it's not complicated for police officers to read you those rights. There's only 2 of them. It's the right to remain silent and the right to an attorney. And they just have to ask if you waive those rights at the end. It's 4 declarative sentences and then a question. And if police officers choose to ask you those questions without the Miranda warning, well, then they're violating your rights, and those statements can't be used later on in court. So those are my top 5 defenses to DUIs and also DWAIs here in Colorado. My name is Austin Lux. I'm an attorney. I practice in Colorado Springs, Colorado, and I want you to know your rights and know the law.